All right, good afternoon. Can everyone hear me okay? All right, welcome. Thank you to those of us who have joined us in person and also to everyone who is joining us online for this Election Matters 2026 panel, Year in Review, Democracy, Litigation in SCOTUS and the States. I'm Rob Yablon, a professor at UW Law School. Together with Professor Miriam Seifter, I co-direct the law school's State Democracy Research Initiative, which aims to foster research and dialogue on state-level democracy and public law in Wisconsin and nationally. SDRI is co-hosting this event with the university's terrific Elections Research Center, and our Election Matters series is generously sponsored by the law firm Stafford Rosenbaum. In a moment, I'll turn things over to Stafford attorney Zoe Polish, who will introduce today's outstanding panelists. Before that, just a couple of quick initial housekeeping matters. One is that this event has been approved for 1.5 Wisconsin CLE credits by the Board of Bar Examiners. For those of you who are here in person, there are CLE sign-in sheets at the registration table. If you have not yet done so, please make sure that you sign before you leave today. If you're attending virtually, please listen for the passcode that I will give around 4:05 p.m. Central Time. We will provide a link to a Google form in the webinar chat box at that time. Complete that form with the correct passcode by 8 p.m. Central Time today in order to get your credit. The panel will conclude at 4:15 p.m. Second, we do plan to leave time today for a moderated Q&A. And so if you're here in person, please use the index cards that have been provided on the tables to write your questions down. We'll have folks coming around to collect those for me. If you're online, please use the Q&A function on Zoom, not the chat function, to ask your question. And I'll keep an eye on what's been submitted. And I'll do some combining and synthesizing of people's questions to try to get to as many as we can. Finally, a huge thank you to our amazing SDRI team, including Bree Wilde and Melina Wynn, for all of their work to make this event happen. So with that, let me turn it over to Zoe to introduce our panelists.
Good afternoon, everyone. I hope this is working. My name is Zoe Polish. I'm an associate with Stafford Rosenbaum, a full-service law firm with offices in Madison and Milwaukee. We have a robust election and political law practice, and we are very excited to be sponsoring the Election Matters series. Without further ado, I'd like to introduce the panelists. So first, I'd like to start with Christina Arndt, who is Chief Counsel in California's Department of Justice Special Litigation Section, where she oversees California's response to unlawful actions at the federal level. Christina has practiced in California's Department of Justice for 25 years, and before serving as Chief Counsel, she served as the Supervising Deputy Attorney General in the Land Use and Conservation Section, where she represented state agencies that own and regulate land in California. In that role, she led the department's housing justice team, and she's earned her BA from Mount Holyoke College and her JD from UCLA School of Law. Next, I'm going to introduce Julie Murray, who is the co-director of the ACLU's State Supreme Court Initiative, which is a team of attorneys litigating a wide range of civil rights and civil liberties issues, particularly those involving novel state constitutional claims. Before joining the ACLU, Julie was a litigator at Planned Parenthood Federation of America, where she brought challenges to restrictions on reproductive health and litigated cases on privacy, due process, equal rights, and free speech under both federal and state law. Julie clerked for Judge Marcia Berzin on the U.S. Court of Appeals for the Ninth Circuit, and she worked as a litigator with Public Citizen Litigation Group, co-taught courses at Yale Law School and Georgetown University Law Center. She earned her BA from the University of Kentucky and her JD from Harvard Law School. Next, I'd like to introduce Amit Agarwal. Amit is a special counsel with Protect Democracy, a nonpartisan, nonprofit organization and advocacy group dedicated to preventing American institutions from declining into authoritarianism. Before joining Protect Democracy, Amit served as Florida's Solicitor General from 2016 to 2021. He clerked for Justice Samuel Alito on the United States Supreme Court and as a law clerk for then Judge Brett Kavanaugh of the United States Court of Appeals for the D.C. Circuit. Amit has also served as Deputy Chief of the Appellate Division for the U.S. Attorney's Office in the Southern District of Florida. He co-chaired the appellate team for a major national law firm, and he served in the U.S. Department of Justice's Office of Legal Counsel in D.C. He also previously held the Richard W. Irvin Eminent Scholar Chair at the Florida State University College of Law, where he taught a course on the constitutional separation of powers. He earned his BA from Duke University and his JD from the Georgetown University Law Center. And finally, I'd like to introduce Donald Verrilli, who served as Solicitor General of the United States from 2011 to 2016. He's a partner with Munger, Tolles, and Olson and the founder of its Washington, D.C. office. He's argued dozens of cases before the United States Supreme Court, including Obergefell v. Hodges, Moore v. Harper, and California v. Texas. He's recognized as a star individual by Chambers USA and was named Lawyer of the Year for his appellate work in the 2026 edition of the Best Lawyers in America. Before serving as Solicitor General, he served as Deputy White House Counsel and Associate Deputy General in the U.S. Department of Justice. He's also a lecturer at Columbia Law School and previously taught First Amendment law at Georgetown University Law Center. He clerked for Judge Skelly Wright for the D.C. Circuit and Justice William Brennan for the United States Supreme Court. He earned his BA from Yale University Law School and JD from Columbia Law School. Thank you.
Thank you, Zoe. So many thanks to the panelists for joining us here today. In terms of format, I will offer just a few quick words to frame our discussion. Then I'll invite each of the panelists to offer about 5 to 7 minutes of opening comments. After that, I'll ask a question or two of my own, and then we'll turn to the moderated audience Q&A. So in late June, the U.S. Supreme Court traditionally issues the final opinions of its annual term. Typically, and this is certainly true this year, the court saves some of its biggest rulings for last. The justices then scatter for the summer. Their exhausted law clerks settle into their sensory deprivation tanks to recuperate. And panels of experts like this one assemble to offer their takes. What makes this event distinctive is that we're simultaneously narrowing and broadening the scope of our coverage. The focus today is narrower than the standard post-term review because we're zeroing in on democracy-related rulings. And there were some big ones from the U.S. Supreme Court this term. Perhaps the most high-profile election case was Louisiana versus Calais, which gutted Section 2 of the Voting Rights Act. There was also National Republican Senatorial Committee versus Federal Election Commission, a campaign finance case that gave political parties and candidates more leeway to coordinate their expenditures. There was Watson versus Republican National Committee, which held that federal law does not bar states from counting mail ballots that are postmarked by Election Day but arrive later. There were also some non-election cases that do have important democratic implications, including cases involving the scope of executive power. Trump versus Slaughter and Trump versus Cook, for example, considered whether and when Congress can insulate federal officials from presidential removal. Learning Resources versus Trump addressed the president's authority to impose tariffs. And Trump versus Barbara rejected a presidential effort to roll back birthright citizenship. But while we're limiting ourselves today to democracy cases, we're not limiting ourselves to the U.S. Supreme Court. So the other part that makes this event distinctive is that we're broader than the typical end-of-term recap, and that we're looking not just to the U.S. Supreme Court, but to state high courts as well. Every year, the U.S. Supreme Court decides several dozen cases. The nation's state Supreme Courts collectively resolve several thousand, many of which are highly controversial. State high courts have recently confronted or are currently confronting questions about voting rights, redistricting, campaign finance, direct democracy, the balance of power within state government, and much more. And we do ourselves a disservice when we become so preoccupied with what's happening at the U.S. Supreme Court that we lose sight of state judicial developments that can also significantly impact the health of our nation's democratic system. So with that, let me turn things over to the panelists for their opening remarks. We'll start with Don and Amit, who will talk primarily about the U.S. Supreme Court, and then we'll go to Julie and Christina for a more state-oriented perspective.
Thank you, Rob. It's really great to be here. I always love being in Madison, and thanks to all of you for coming out and all of you who are online watching. So as Rob said, at this time of year, we are reminded, for better or worse, that the Supreme Court is a dominant force in our public life. It's really put itself at the center of our public life in lots of ways, increasingly over the last 10 years or so. This term was another super consequential term for the reasons Rob identified. We can debate, as the commentariat already is, well, is the court a moderate court that stood up to Trump? Is it a court that is, consistently advancing conservative priorities? Is it something in between? One thing is pretty clear, though, with respect to democracy and the political process, the court has been and continues to be a very interventionist court. It is in many really important ways, it is dictating the terms on which our democratic process unfolds. And there were three really important cases this term. I'm going to just in the opening here talk about two of the three. The one I'm not going to talk about, the case National Republican Senatorial Committee. It's another one of these campaign finance cases in which the court has continued on its sort of systematic endeavor over the last 20 years to dismantle the campaign finance regime. It's a case in which a majority of the court held that prior restrictions on political parties coordinating their expenditures of funds with candidates violated a prohibition the Supreme Court upheld in 2001. They've changed their mind about it and decided it's unconstitutional. So we can talk about that later if people have questions or if we have time. I want to focus on two other cases. One is Republican National Committee versus Watson, which is a case about ballots, mail-in ballots, and the other one is the Louisiana against Cali case that Rob mentioned. I want to talk about Watson first in a little more abbreviated form and then a few more minutes on Cali. Watson was a case that and just full disclosure here, I was involved in on behalf of the Democratic National Committee, so obviously I have a biased point of view as a litigant in the case. Nevertheless, this is a case filed in the run-up to the 2024 election by the Republican National Committee in Mississippi, and what it did was challenge Mississippi law, which is a law that 29 other states also have, which permit mail-in ballots that are cast by Election Day but arrive within a fixed period in Mississippi 5 days after Election Day to count as valid votes. It was challenged on the ground that it was preempted by the federal statute, which sets Election Day as the Tuesday after the first Monday in November. The argument was, well, the election has to be on that Tuesday, and any votes that arrive in the mail after that Tuesday, even if they're mailed by that Tuesday, shouldn't count. Federal law didn't want them to count. I personally thought that was crazy. And the district court in the case, conservative district judge in Mississippi, agreed, threw the case out, went to the United States Court of Appeals for the Fifth Circuit, and for the many lawyers in the room, you understand that's the most conservative court of appeals in the country. And they said, no, that's not crazy. In fact, it's correct. And then the case made its way to the Supreme Court, and the court, in a 5-4 vote, reversed the Fifth Circuit and said, no, the federal election day statute doesn't preempt these state laws. And basically, it was a fight about what does the word election mean in these statutes. The statutes say the election shall be held on the Tuesday after the first Monday. And what the RNC and the challengers and the 4 dissenters in the Supreme Court concluded was, well, the word election means the combined action of the electorate and election officials such that the vote, the choice of the electorate about who's going to be the winning candidate in election must be known to the election officials by the close of election day. And therefore, ballots that come in after can't count. Now, why anyone would think that's what the word election means, as opposed to the collective choice of the voters, the casting of the votes, which determine who's the winner, I don't know. Well, but, 4 justices of the Supreme Court agreed, but a 5-justice majority, an opinion by Justice Barrett, said, well, no, Congress, when it passed this statute, all it wanted to make sure of was that every state held its election on the same day, so there couldn't be shenanigans, say, in presidential elections. People vote in one state and then go to another state and vote later in another state, et cetera. It wasn't thinking at all about these kind of electoral practices, which over the course of our country's history have evolved quite a bit. In the early 19th century, everybody got together at the schoolhouse or whatever and argued and voted in person. It wasn't even a secret ballot. And things have evolved over time, such, after World War I, lots of states adopted absentee voting, mail-in voting. And by now, as I said, 30 states have said that ballots that are in the mail by election day but arrive within 5 days should count. So to me, it was a little dismaying that this was a 5-4 vote, because I really didn't think there was, as you could tell from my disparaging tone, a substantial legal argument in favor of the proposition that Congress had intended to dictate the question of whether states could allow these ballots to count. But at least there were 5 votes saying, no, Congress didn't do that. And it would have been an extraordinarily convulsive thing had the court come out the other way and invalidated these practices in 30 states, a few months before a major congressional election. Calais, Rob described it as gutting the Voting Rights Act. I think that's a perfectly fair description of the case. This court has, for some time now, been of the view that the Voting Rights Act, even though it was once an important enactment by Congress in order to deal with the systematic discrimination in voting of the Jim Crow era, had outlived its usefulness and had become, as Justice Scalia said to me when I was arguing and losing the Shelby County case, it's become a racial entitlement. So they've been sort of systematically dismantling it. As I said, I argued and lost Shelby County, which was about Section 5 of the Voting Rights Act, which is a provision that required states that had a long history of discrimination in voting practices to submit to the Justice Department for review any changes in their electoral practices. The court threw that out on the ground that it was unfair to treat some states differently than others with respect to voting. And that the court, rather than Congress, would make the judgment about what was needed and wasn't needed with respect to these kinds of reviews. And then there have been other cases along the way sort of chipping away at the other key provision of the Voting Rights Act, Section 2, which was a provision that basically, as amended in the 1980s, held that, or provided that electoral practices, things like how you design ballots, where you set polling places, and how you draw districting lines, how you redistrict, could be subject to invalidation, essentially if their effect was to discriminate on the basis of race. The statute was enacted because the Supreme Court had concluded in the late 1970s and early 1980s that the 15th Amendment itself protected against only intentional discrimination. So just showing that electoral practice or the way district lines were drawn had a discriminatory effect wasn't enough. And the argument was, well, yeah, but people aren't stupid. They don't say they're discriminating on the basis of race. They do subtle things that disenfranchise minority populations. And so you need to have a test like this. Congress enacted a test like that. It's been applied for 40 some odd years until now. And a 6-3 majority of the Supreme Court concluded that, to allow the courts to reform districts or do other things on the basis of just proof of discriminatory effects would be unconstitutional. So we're going to reinterpret this provision that's been interpreted this way for 40 years to no longer allow courts to intervene based on the essentially showing of discriminatory effects. And that it's only when the discriminatory effects are so incredibly strong that they permit no other inference but that they were adopted for discriminatory reasons that we will allow enforcement of the act. Now, as a practical matter, what that means is that the so-called minority-majority districts, which have been drawn in conformity with the Voting Rights Act in many jurisdictions, not just in the South, but across the country for 40 years and, and currently in place, are all subject to challenge. A number of them have already been challenged and thrown out, and there's been redistricting in the run-up to the 2026 election. There will be more in the run-up to the 2028 election, and there'll be more after that. Extraordinarily convulsive thing. And I just want to make one point about it generally. The 15th Amendment bars discrimination on the basis of race in Section 1. Then there's a Section 2 of the 15th Amendment, and what it says is the Congress shall have the power to enforce this article by appropriate legislation. And the essence of what's happened in the Shelby County case with respect to Section 5 and in the Cali case with respect to Section 2, the Supreme Court has said, well, okay, fine, but we decide what's appropriate legislation, even though the Constitution says Congress shall have the power to decide what's appropriate legislation. The court has taken that to itself and said, we have decided that race should almost never be considered, ever, in thinking about government action and government taking its action. And even if Congress made a different judgment in the Voting Rights Act, exercising the power the Constitution gave it to decide what's appropriate legislation, we're going to overrule that and decide it's not appropriate legislation. And so whatever one may think about the question of racial preferences in university admissions, et cetera, this is a constitutional provision that says Congress shall have the power. And I think where the court is in Calais, where it was in Shelby County, whereas in Cali has, we're way far away from what the Constitution says about that. So with that, I'll turn it over to Amit.
Thank you very much. It's great to be here today. I am a big fan of the State Democracy Research Initiative and of the incredibly talented staff that runs that program and put together this event for us today. So when I initially got this invite to participate in this discussion, at first I was really excited to be a part of the program. That was, of course, before I found out that it was going to be my task to talk to y'all about the Supreme Court immediately after Don Verrilli. So I don't.
Oh, please, come on.
I don't know who made the decision that I should go after Don, but that really doesn't seem fair. In any event, what I will tell you is this. I may not be a former Solicitor General of the United States and have Don's expertise, if that's your thing, but I will make up in the confidence with which I express my views for any lack of expertise that I may have about the last Supreme Court term. And boy, do I have a lot of views about the last Supreme Court term, including a case that I was fortunate enough to have the opportunity to participate in, and that's the Trump v. Slaughter case that you heard a few references to in some of the preceding remarks. So I was asked to talk to you all about cases from the last term implicating the scope of executive power. And a couple of big cases that implicated executive power last term were Trump v. Slaughter and Trump v. Cook, which dealt with independent agencies, including the Federal Trade Commission and the Federal Reserve, respectively. And basically, in both cases, the question is whether the president had the authority to fire the head of the FTC or a member of the Board of Governors for the Federal Reserve. And the court came out in different ways in both of those different cases. And I think it's really interesting for us to put those two decisions side by side, both to figure out sort of what the state of the law is at this point in time, and also what maybe broader implications may be for American democracy going forward. So let's start with the Trump v. Slaughter case. I had the opportunity to represent Commissioner Slaughter in her legal challenge. And I guess I would give you some background about the case first, and then we can talk about the legal issues. So Commissioner Slaughter was first appointed by Donald Trump to the FTC during President Trump's first term. Then she was reappointed by President Biden for a second term. Both times she was unanimously confirmed by the United States Senate, which is something that doesn't happen very often. So someone with just absolutely impeccable credentials and respected on both sides of the aisle. At the beginning of his second term, President Trump decided that he would fire Commissioner Slaughter and the other Democratic appointee, that is Commissioner Bedoya. And the statute, the FTC Act that governs these removals, says that the president does have the authority to fire a commissioner of the FTC, but it just says he has to have a good reason for exercising that removal power. And in the language of the statute, he can fire a commissioner, but only for inefficiency, neglect of duty, or malfeasance in office. Now, President Trump said, I'm not alleging inefficiency or neglect of duty or malfeasance in office, and nevertheless, I'm asserting the authority to fire Commissioner Slaughter in violation of the FTC Act's for-cause removal restriction. In other words, was asserting a kind of absolute illimitable power to fire commissioners of the FTC, not just for a good reason, but also for a bad reason or for no reason at all. So he attempted to remove her from office, and she brought suit in federal district court. This is the U.S. District Court for the District of Columbia. The district court ruled in reliance on a 1935 Supreme Court precedent, which unanimously upheld the exact same for-cause removal provision. The district court said, you can fire Commissioner Slaughter, you just have to have a good reason. And it's not a good enough reason to say that you disagree with her policy views. One of my favorite lines from the district court's decision was where the district court said, Article 2 of the Constitution, which gives the president the power to take care, the duty to take care that the laws be faithfully executed, requires that the president faithfully execute the law, not his own policy preferences. So that was the rationale for the district court's decision. The district court then denied a stay, what we call a stay pending appeal. A divided panel of the Court of Appeals, similarly relying on Supreme Court precedent, denied the stay pending appeal, and President Trump then took an appeal to the Supreme Court of the United States. And the Supreme Court first granted the stay pending appeal and also granted what's called certiorari before judgment. That means they decided to hear the case before the D.C. Circuit even had the opportunity to pass on the merits of the case. And so this all happened kind of in a lightning speed, at least by litigation standards. The case started in March, and it was argued in the Supreme Court in December. And the court at the end of this term, just on the second to last day of the term, issued its decision. Now, the government made basically two arguments and raised two questions for the court's consideration. The first argument that they made was that the for-cause removal provision of the FTC Act violates the constitutional principle of the separation of powers. And the second argument, which is, I think, an underappreciated aspect of the case, something that hasn't gotten all that much attention, is that even if the FTC Act is valid, and even if the president is openly defying the statute, that there's still nothing that any court anywhere at any time can do to remedy the violation. That is to say, there is no judicial remedy that could be had in any forum whatsoever. So those were the two questions that made their way to the court. And on the second to last day of the term, the court decided the case and ruled in favor of President Trump on the first question presented. That is to say, it ruled that the for-cause removal restriction of the FTC Act does violate the constitutional principle of the separation of powers. That is, as I mentioned before, the exact same provision that was unanimously upheld by the Supreme Court in a seminal Supreme Court decision called Humphrey's Executor v. United States back in 1935. And what the court essentially said is, look, over the years, we've issued a series of decisions in which we have expressed a certain amount of doubt and skepticism and rejected certain aspects of the reasoning of the Humphrey's Executor case. And so we're not really sure that there's all that much left of the reasoning of Humphrey's Executor. And to the extent that there is anything left, we reject that, and we're overruling this foundational precedent. And so that was the way that the court was able to reach a different decision than the decision that it reached in 1935. And I will have a lot to say about that maybe later on in our discussion. But that was the ruling with respect to the first question presented. On the second question presented, the court did not really address the merits of the government's argument because it ruled that the firing was illegal. But that issue does have a lot of practical significance going forward, including with respect to the Trump v. Cook case, which is the second case that I was asked to talk to you about. That's the Federal Reserve case. And so, so here's what's going on with that case. last year, the Federal Reserve was issuing a series of decisions on interest rates that the President of the United States disagreed with, including one of the governors, Governor Cook. And it was alleged by the director of the Federal Housing Finance Agency, and I believe a social media post, that Governor Cook had allegedly engaged in fraud in connection with a mortgage application that preceded her tenure on the Federal Reserve. Shortly after that, the president made a statement that he lacked confidence in Governor Cook and that she should resign, and that if she didn't resign, he was going to fire her. And she did not resign. And a few days later, the president fired her, and he issued a statement explaining that he didn't have confidence in her integrity, and he was dismissing her. But here's one interesting aspect of the case: for cause. You might remember that the FTC Act allowed the president to fire a commissioner of the FTC for cause, and the president asserted the power to remove an FTC commissioner without cause in violation of the statute. Well, when it comes to the Federal Reserve, the president argued, he didn't try to argue that he doesn't have to have cause. He said, I satisfy cause because I'm relying on this allegation of mortgage fraud. And interestingly, in the statement that was made, he didn't make a finding that Governor Cook did engage in any kind of fraud. Instead, what he said was, I have reason to believe that you may have engaged in some kind of mortgage fraud, and that causes me to not have confidence in your integrity. So he was arguing that he satisfied the for-cause removal provision of the statute. Governor Cook challenged that attempted removal. It goes to the district court. The district court decides to what we call enjoin the removal. That means to prevent the president from removing her from office, arguing that he had not made the requisite showing that she had violated, that there was cause supporting her removal. And then the president appealed that to the Supreme Court. And something really interesting happens at the Supreme Court. And that is, you might have heard a lot recently about the emergency docket, and sometimes referred to as the shadow docket. Often those rulings will be relatively sort of short rulings that are typically issued without any kind of oral argument, without full adversarial briefing. Well, the court decided in this case that it was going to have full briefing and even set the case down for argument, even at the stay stage of the litigation. This is President Trump is asking the Supreme Court to issue a stay pending appeal, basically saying, look, while this litigation is ongoing, Governor Cook should not be allowed to stay in office. And the Supreme Court decided to go through a fairly elaborate process just to decide that stay application. So the argument was held in January. And on the second to last day of the term, the exact same day that the court issued the Slaughter decision, the Supreme Court decided by a 5-4 vote that it would deny President Trump's application for a stay pending appeal. In other words, would allow Governor Cook to keep her job during the pendency of the litigation. Now, the narrow basis for the ruling is that under the statute, the court finds that Governor Cook is entitled to a certain amount of process before she is removed. And in particular, she's entitled to notice and a meaningful opportunity to be heard. And the court decides that it is substantially likely that she will prevail on her contention that she has not been afforded the requisite process. So that is kind of the narrow basis for rejecting the application for a stay pending appeal. But here's the really interesting part, is in the course of issuing that decision, the court also says, and by the way, the for-cause removal requirement in the Federal Reserve statute is constitutional, even though nobody was questioning that provision. So President Trump had not even tried to argue that the for-cause removal provision of the Federal Reserve Act is unconstitutional. And nevertheless, the court went out of its way to affirm the validity of this provision that effectively protects the independence of the Fed. Another interesting aspect of the case has to do with the remedial issue that I adverted to in connection with the Slaughter case. And that is, like in the Slaughter case, President Trump argued, even if my firing was illegal, there's still nothing that you can do about it. And in the context of the Cook case, the court emphatically rejected that argument. And what it said is, at least at the preliminary injunctive relief stage, that at the early stage of the litigation, if the removal is really illegal, then a court can order a meaningful remedy. In other words, the court can say you're not allowed to get away with doing something that is illegal. And in the process of issuing that ruling, the court also effectively rejected the Trump administration's argument in the Slaughter case about you can't have meaningful permanent relief if you illegally fire an FTC commissioner, because the court said historically you could get certain kinds of relief, for example, like in the form of what's called mandamus to remedy an illegal removal. So those are some interesting aspects of the case. Now, I said earlier, it's kind of interesting to put the Trump v. Cook case side by side with Trump v. Slaughter. And what do you conclude from putting those cases side by side? And it's kind of tricky. One thing that I conclude is that the conservative justices are not a monolith. Sometimes we talk about the court as if it's just one institution, if it's just kind of has a single set of beliefs, and maybe you like it and maybe you don't like it, but you praise or criticize it as if it's a monolith. And I think what these two decisions, along with some of the other decisions from this term, really show us is that there is quite a range of views, even among the conservative justices, and sometimes kind of hard to predict what types of considerations will predominate in any particular case. And so, for example, in the Trump v. Cook case, you see really kind of fairly explicit articulations on the part of two of the conservative justices, that's the Chief Justice and Justice Kavanaugh, that they are concerned not just about kind of the technical legal issues, but also with the practical impact of the ruling. And that's part of what is animating the court's decision to go out of its way to affirm the constitutionality of the Federal Reserve's protections, even though that issue is not technically before the court. And on the other side, you see Justice Barrett in dissent pointing out that the court's decision to protect the independence of the Fed is in, I think, what she calls, quote, substantial tension with the court's decision in Trump v. Slaughter, because in the Slaughter case, the court is embracing a theory that the executive power that is vested in the president requires that the president have a kind of plenary power to remove officers who are exercising what is called the executive power. And so there is that tension. And I think what you see is among the conservative justices, different kinds of receptivity to both theoretical arguments, to doctrinal arguments, but also to extra legal prudential types of arguments. And that seems to be, including practical considerations, that seems to be really kind of animating a lot of the important decisions in that case. So a couple of other quick points about the implications for democracy before I turn it over to my fellow panelists. One thing that really occurs to me about the Trump v. Slaughter case is this. Intelligent people of goodwill can disagree about all kinds of things, including how do you interpret the meaning of these broadly phrased ambiguous constitutional provisions like the vesting clause of Article 2. From a democracy standpoint, I think it's worth emphasizing the enormity of the change that has been wrought by the court's decision in Slaughter and how it affects democratic processes. And here's what I mean by that. It's one thing if the court back in 1935 had said, look, we just think as a matter of first principles, there shouldn't be these laws that restrict the president's removal power, and you shouldn't have independent agencies like the Federal Reserve, like the Federal Trade Commission, like the Nuclear Regulatory Commission and the Federal Communications Commission. And if they had said that back then, and everyone knew what the ground rules were, that's one thing. But what happened was exactly the opposite. The court unanimously signaled to Congress and to presidents that it's okay to create these independent agencies that would enjoy at least some degree of insulation from partisan political control. And in reliance on that decision, Congress and presidents worked together to create what are now more than 24 what we call traditional independent agencies. I mentioned some of them, the Nuclear Regulatory Commission, the Federal Trade Commission, the Federal Reserve, the Securities and Exchange Commission. It goes on, the Federal Elections Commission, the Election Assistance Commission. It goes on, and they do absolutely vital work on behalf of the American people. And I guess the key point that I would make is this: Congress vested enormous powers in these agencies on the assumption that those powers would not be under the control of just one person. And if you retroactively destroy the independence of the independent agency, it doesn't just, in an abstract technical sense, affirm the president's constitutional power to remove. What it does as a practical matter is transfer a vast reservoir of statutory authority from what used to be independent agencies to now just one person. So that is a really huge change, I think, whether you like it or not, a really huge change in the workings of American governance. And it is one that is done in demonstrable opposite, kind of over the will of the people's elected representatives in Congress working with presidents to create all those independent agencies over the years. That's one point. The second point, I guess, related to that I would make is this. The theory underlying the court's decision largely has to do with this theory of democratic political accountability. And the idea is that even though the text of the Constitution doesn't say anything about the president having any kind of removal power, much less an absolute and illimitable removal power, that nevertheless the sort of the structure and text of the Constitution support this conclusion that any significant governmental power must be vested in officers who are accountable to the president, because the president is in turn accountable to the electorate. Now, think about this for a second. Suppose that you don't want to live in a society where the president of the United States completely controls, say, for example, the Federal Communications Commission. Suppose you don't want to live in a society where the president can call up the head of the Federal Communications Commission and say, there's a late night comedian out there who's expressing thoughts with which I disagree. And I want you to use the formidable power at your disposal to go after the television network that is providing a platform for that late night comedian. Suppose you don't want to live in that kind of society. Who would you hold accountable? And, under the court's ruling, it's really hard to identify any politically accountable actor that you could hold accountable. Why? Because Congress never voted to make the FCC or any other commission completely under the thumb of the president. And even if they had, those Congresses are long gone. So all of that to say that just from the standpoint of democratic political accountability, I think there is kind of a real problem with retroactively destroying the independence of traditional independent agencies. And that's even just kind of leaving aside what are the effects on the workings of American democracy when you concentrate this much power just in the hands of one person. Those are a couple of the big picture thoughts that I had about both the Trump v. Slaughter case and the Trump v. Cook case. And there's a lot more that we could talk about, and happy to have that discussion with you later on in this conversation.
Thank you, Julie.
Great. Well, it's really wonderful to be here with all of you. It is a treat to be on this panel. I will say, following the federal cases with I believe my charge was kind of an overview of state Supreme Court cases in the democracy space. It is a big charge. And obviously, the obvious reason is there are a lot of states. I can say my team at the ACLU, we look at cases that are coming up to state Supreme Courts where that's possible. It's where you can every couple of weeks. And there are dozens and dozens and dozens of cases touching not just on voting, but on some of these, really weighty separation of powers issues and adjacent issues all the time. So I guess I will preface the rest of my remarks by saying what I'm giving you today is necessarily a snapshot. However, my hope is that it is a little bit of a brighter story than what we're seeing at the U.S. Supreme Court and on the federal level. And, for those of you who are not steeped in state courts or state constitutional law, I did want to highlight a few kind of unique aspects of state democracy law that I think in talking about some of the cases we've seen in the past year really are just important to understand. One is that there's just a lot more in state constitutions than in the federal constitution about democracy and how it is supposed to work. So all but one state contain some sort of express right to vote in their state constitution. About half of states provide some sort of citizen ballot initiative process where the citizenry can decide to amend the Constitution. They can decide to come up with their own legislation, irrespective of whether a state legislature has been captured and would support those kinds of initiatives. So there are these hooks in state constitutions that really just don't exist under federal law. There are also under state statutes, Dawn talked about the gutting of the Federal Voting Rights Act, which is, devastating and will continue to have devastating consequences for majority-minority districts. That said, many states have their own versions of voting rights acts, and more could adopt them. Those were not at issue in the Calais case. They often go beyond addressing redistricting to talking about voter intimidation or suppression, for example. And I think that there is good reason to believe that those voting rights acts could, as we move forward, provide at least a backstop for some semblance of fairness in elections in the states that have them. So, and then my final remark, just in terms of the distinctness of state constitutions and state law, is that many states have, whereas the U.S. Supreme Court in a case called Rucho a number of years ago said, we're out of the business of deciding whether something is constitutional because the state is trying to distinguish between partisan affiliations and essentially creating these partisan gerrymanders. That may be the law at the U.S. Supreme Court, but it is decidedly not the law in states. And so, or at least some states. So this is something where there has been a lot of litigation in recent years over whether partisan gerrymandering claims can be brought under state constitutions. So with that said, there are more hooks for court intervention at the state court level. And we see some of those in a range of ways. So I wanted to highlight kind of 4 contexts in which there have come up in the past year and give you a sense of the range of litigation that we're seeing. In terms of states weighing in on redistricting, obviously, there has been quite a bit of mid-decade redistricting, which I think we're going to hear about next. But those redistricting efforts very much are coming up in state Supreme Courts, as are challenges to earlier redistricting. So earlier this year, the Utah Supreme Court refused to essentially stay a lower court order that had blocked a state legislative gerrymander that essentially for those of you who know Utah geography, Salt Lake City is really a condensed Democratic voting bloc, and the state legislature had overridden a citizen initiative to bar partisan gerrymandering and essentially cracked the voters in Salt Lake City to try to prevent the election of Democratic officials. That attempt was blocked by a trial court, and the Utah Supreme Court, to its credit, I think, seeing that this was in direct contravention to a citizen initiative that did not want partisan politics deciding where people get to vote, said we're going to leave in place that trial court opinion, which is an important decision, certainly in that state, and I think goes to show the power of some of these state constitutional provisions with respect to partisan gerrymandering and other unfair practices in our elections. The other thing that I wanted to note is that, we've seen in federal cases recently, past like 10, 15 years, quite a bit of litigation over state practices to essentially suppress the vote. So, the mail ballots, counting of mail ballots, if it arrives after the election, is it going to count? Those types of questions. States have a lot of leeway to design their own election processes. And they also, because they have their own rights to vote, generally, don't have to follow the federal standards. So whereas the federal courts have often applied a somewhat watered down standard for determining whether a restriction or some kind of regulation on voting violates a right to vote, states aren't bound to do that. And I think, one example of this that's helpful, similar, it's not a right to vote case, but it came out under a free speech rationale, was a case out of the state of Missouri where the state legislature had tried to essentially regulate people who were what was called soliciting voter registration. And the Missouri Supreme Court, which is not, it is not known for being the most sort of on the liberal side, said, no, you can't do this. This is essentially regulating core political speech where people are trying to encourage people to vote and telling them about absentee ballots. And therefore, we are going to subject this to the strictest review that we would in our courts, in a way that I think set up a really interesting dichotomy with how something like that would be viewed at the federal level. And then I wanted to say a word about citizen initiatives, because as I mentioned earlier, there are about half of the states have some form of citizen initiative, and particularly in those states that have just wild gerrymandering that has substantially kind of when you look at their representation and where the sort of general politics of the state fall, there's sort of wide discrepancies. Protecting access to citizen initiatives is incredibly important to our democracy in the states. And so we've seen, this year, I don't know that I'd say there's more, but there is certainly a continued stream of litigation over citizen ballot initiatives, efforts by hostile state attorneys general to try to get in and muck around with what goes on the ballot, change the way things are described to confuse voters. And although, states come out in different ways on some of those ballot initiatives, I think, we have seen, for example, this year in Montana, the Montana Supreme Court, they're saying to the Attorney General, no, you cannot describe a state constitutional amendment that would forever make judicial elections nonpartisan. You cannot describe it in a way that sort of is 3 times as long, confusing, and uses terms that aren't even defined by the proposed amendment itself. And then the final kind of bucket of cases that I want to highlight really ties to the earlier 3. So I've highlighted some state courts that have really stepped in and said, no, we are protecting the citizens' voice in our elections and in our democracy. And those courts, in many instances, are under attack by state legislatures. So we have seen a real, and this past year, certainly continued pace of targeting of state court systems. And I think another story in terms of the trend of what we've seen in the past year is increased litigation over legislative efforts to essentially strip courts of their power. So Utah, for example, has 3 cases pending right now on whether constitutional challenges to state laws can be effectively plucked out of the courts that they've been litigated in for years and sent to these new judge panels in a transparent attempt to try to make it harder for constitutional litigants, and for the legislature to essentially act as its own decision maker as to the constitutionality of laws that it passes. So those are kind of 4 different buckets. Like I said, this is a smattering of cases, not a comprehensive list, but hopefully we can get to some additional examples and discussion during the Q&A.
Good afternoon. I am delighted to be here in Madison. And of my 3 panelists here, my guess is I'm going to be the weediest. I am going to talk a little bit today about some California developments in election law that bear on election integrity. So the first thing I want to talk about is Proposition 50. That is California's redistricting initiative that was on the ballot in November. It was passed in response to, or is put on the ballot in response to Texas's redistricting that would favor Republicans at the midterm election. In California, our voter initiative, our redistricting is generally the purview of an independent election commission. So that commission is a bipartisan group. It includes both Democrats and Republicans and independents that act after every census to do the redistricting of California. And perhaps ironically, that commission was enacted by 2 different voter initiatives in response to gerrymandering, because if you let the legislature do it, the legislature is going to create districts that favor the majority in the legislature. The Proposition 50 is specifically states that it is designed to hand the power back to the Redistricting Commission in 2030 after the next census. It passed overwhelmingly by 64% of Californians, about 3.3 million more votes. I think it is perhaps one way to look at that is not so much that Californians were looking for a Democratic majority, but Californians were looking for congressional balance at the midterms. After all, it was started in response to Texas. It was challenged before the California Supreme Court by a group of Republican legislators twice. Once before the final vote in the legislature took place, that would put it before the voters, and then again after it was passed. And both times the California Supreme Court denied it in 2 days with a 1-sentence decision without any further comment. That's not unusual for the California Supreme Court in cases like this, that it will be that brief with no explanation. Then it was heard before a 3-judge district court panel where it was denied. And then, as you probably know, went to the U.S. Supreme Court and they declined to get involved. Following up on Proposition 50, we had a county sheriff in California seize the election ballots after the Prop 50 election. So after the election, there was a voter advocacy group who claimed that there were miscounted votes in Riverside, and the registrar of voters specifically debunked that. But the sheriff, Chad Bianco, who was running for governor at the time, decided that he was going to seize the ballots. Now, mind you, California's election law is quite clear that the ballots are to stay in the custody of the registrar of voters. The way it's set up is that the registrar of voters holds those ballots for 6 months after the election, sealed, and then destroys them. There are 2 exceptions to that. One, if there's a contested election, and 2, if there is a criminal proceeding that alleges either fraud in the election or a miscounted signature on a mail-in ballot. Most California votes by mail-in ballot. So very specific exceptions to that. In no case, even under those exceptions where the registrar of voters won't destroy the ballots, in no case do the ballots leave the registrar of voters. And the election code is very clear that the ballots are to stay with the election official. In California, the Attorney General has supervisory authority over county sheriffs. And so when we heard that the sheriff had received a search warrant for these ballots, our office asked him to pause, and in response, he executed the search warrant and held a press conference about it. I think that let me pause here for a few sort of big picture issues that are posed by this. One is that it's important for election integrity to keep the ballots in one place, to keep them within the supervisory authority of the person who's responsible for the election. Likewise, it's also important to use the criminal powers to prosecute crimes at the risk of stating the obvious. But when he seized the ballots at his press conference, he specifically said he didn't know if there was anything wrong or not, but he wanted to find out if there was a miscount, which doesn't sound like probable cause. And finally, it's useful. Counting ballots is not something that just anybody can do. And we should have the people who are trained at counting ballots count the ballots. And law enforcement officers are trained at different things, and they are expert at different things, but not determining signatures on mail-in ballots and processing ballots. So all of those things were of concern to us. We challenged the action in the Supreme Court, specifically looking at our office's authority over the sheriff. In addition, it was challenged by Riverside County residents who said that it violated their rights to have when he seized their ballots. Both of these cases are before the California Supreme Court now. We expect them to be heard together in August. We filed an amicus brief in the related case about the authority to take the ballots. Our amicus brief sort of dives into the history of the elections code that governs this. And I won't go too deep here, but that elections code has been around since the 19th century. Since 1863, because in 1892, there was a prosecutor who sought to seize the ballots. And the registrar of voters said, no, I can't give you the ballots. The statute says I have to keep them. And the registrar of voters went to jail because he wouldn't give up the ballots. And the California Supreme Court, in a habeas action, said, no, the registrar of voters was in fact complying with the law. And if the legislature wants to change that, then the legislature can. And indeed, the legislature spelled out explicitly the terms of of when ballots could be reopened, not taken from the registrar of voters because they have to stay there. So that is before the California Supreme Court now. And also California has passed some more secure laws specifically directed at this issue. Finally, in one other challenge to election administration, I wanted to talk about the federal government's request for states' voter rolls. So the federal government has made requests to all states to turn over their voter rolls to the federal government. The voter rolls contain our personal data. They contain your names, social security numbers, home addresses, voting history, party registration, and they requested the voter rolls from every state. 16 states said, "Okay, here you go," and the rest of the states said either you can have what is public information, or no, you can't have anything. And the federal government has sued 30 states plus the District of Columbia. California was one of the first sued. We brought a motion to dismiss that was granted, and we recently had argument in the Ninth Circuit. There have been 11 other motions to dismiss that have gone through hearing, and all 11 were granted because there simply is no ground for the federal government in the laws that it cited to have that information. And in addition, it does not preempt state privacy laws. I will note that Wisconsin brought a motion to dismiss its case, which was granted, and the federal government's deadline to file an appeal is next month. And with that, I'll pass it back to you.
All right. Thank you. Thank you to all of the panelists for those remarks. So I want to be mindful of time. We have about 10, maybe if I stretch it, 11 or 12 minutes for questions. I will just ask one of my own. I've got a few questions up here. I would encourage you, if you're in the room, write those questions down. They'll get brought up to the front. If you're online, submit your questions. I'll also do, before I ask my question, my one bit of obligatory CLE housekeeping. And so for those of you who are attending virtually, and if you wish to receive CLE credit, I will now provide the passcode for today. The passcode, I was told, should not be a boring court-related passcode. Instead, we will use the summer-friendly passcode, BEACH. That is BEACH, B-E-A-C-H. That is not case sensitive. Please go ahead and enter that on the online form in order to get your credit. Okay, so the one question that I will ask, you've mostly talked about the cases that have been decided this past term, although we heard a little bit from Julie and Christina about some pending cases, the Utah sort of judicial independence cases, the Riverside ballot seizures cases, which are still to come. But as you all look ahead to the coming year, what do you see as the most significant democracy-related cases or issues to watch, either at the U.S. Supreme Court or in the states? What are you all keeping an eye on? Anyone want to jump in first on that one?
Well, I'll start, and I think the answer is we don't know yet, at least with respect to the lower courts. We have a very important federal midterm election coming up. I think there's reason to believe there's going to be unprecedented levels of mischief wrought by the federal government with respect to the voting practices in the states. Will ICE agents be deployed to polling places to intimidate voters? Will the Insurrection Act be invoked on the theory that the communists are about to take over? Will other kinds of federal actions that frankly some of us worried about in connection with the 2020 election, will they come to pass? A lot of what you heard about with respect to the voting rolls, that those issues are in the district courts, but they're going to percolate up to the courts of appeals. There are going to be issues, I think, respecting, efforts to try to assert. Well, you may have seen in the news yesterday that all 50 states received letters from the Department of Justice threatening criminal prosecution of state election officials if they allow non-citizens to vote. There's a long litany. I don't know exactly what the litigation is going to be, but it seems certain that there's going to be litigation, that it's going to matter, and it's going to unfold over the course of the fall, and it could be quite important.
I mean, I think at the state level, I would assume that we will see, as Don said, quite a bit of litigation around the midterm elections, both leading up to the election and after. I also think that, one thing that I will be watching is sort of post-Calais fallout and the extent to which we are seeing Calais-like arguments come up in states. I think there are certainly good arguments that the rationale of Calais shouldn't preclude states from going a different way, and that state VRAs are distinct. But I do expect that there will be some litigation over that, and certainly an appetite for those who cheered Calais to see similar rollbacks at the state level.
I apologize for speaking twice, but there's one actually really big one that I didn't mention that I think people should be kind of having on their radar screen, which is January 3rd, 2027 is the date under the Constitution when the new Congress is sworn in. What if the existing congressional leadership says, well, there's been rampant fraud in Illinois and New York and California, and these 27 representatives who appear to have won the vote, we're not going to seat them because we think they won by fraud. Will that happen? I don't know. But it's something that a lot of people are focused on right now as a potential serious risk to the democratic process, and trying to figure out what, if anything, courts would be in a position to do if something like that were to happen.
And I think that's part of why we're seeing so many things like the letter that Don mentioned that went out to all of the state election officials. I think all of that sort of forms a foundation of other potential action, unknowing what it might be. And I also think that the harm of that is not entirely legal. The harm of that is partly one of public perception, because if you plant enough seeds of doubt, then perhaps one of those will bear fruit. Even though you should all know, there's very little misdeeds in elections. In fact, they work like they're supposed to.
Yeah, I mean, I would agree that as a category, the category that I'm most interested in, just like my fellow panelists, is litigation implicating free and fair elections, including, for example, litigation about the Postal Service and the independence of the Postal Service and whether they will be prohibited from delivering mail ballots or allowed to not deliver mail ballots based on really specious reasons, and also efforts to deny federal funding to jurisdictions that don't comply with the federal government's preferred policies, with respect to voter registration and alleged non-citizen voting and things of that nature. We had mentioned the litigation about ballot seizures, which I think is incredibly important. One aspect of that, sort of a related aspect of that is very much on my mind, is the possibility of ballot seizures, not just with respect to a completed election, but with respect to an ongoing election before the election has been conclusively certified. That strikes me as a kind of a real risk in the coming months, and something that that courts and the general public should be deeply concerned about.
Great, thank you. So sobering answer, and an answer that, by the way, unintentionally previews a different panel that we plan to have sometime this fall, looking ahead to the midterm elections. So keep an eye out for information about that one. It was ambitious to try to limit this to 75 minutes. There's obviously a ton to talk about. We're just about at time, but I have to sneak in at least one kind of synthesized question from like the dozen that I got here from everyone. And this does get at a few different things that people have asked about. So there's concern that Don, you expressed, others may have alluded to at the U.S. Supreme Court level, that the U.S. Supreme Court has been receiving some cases that sometimes embrace crazy theories, right? The Watson case, as you said, or the Supreme Court has shown willingness to dispense with many decades old precedent. And it wasn't just in in Slaughter that it did that, but there were other overturned precedents this term. If you are concerned about the direction that the Supreme Court has been going, what are the options for you in terms of reform, in terms of next steps? And to what extent, this is bringing in yet another one of the questions that I got, to what extent can we really rely on state Supreme Courts as a backstop or alternative, or might the U.S. Supreme Court try to interfere with what they're doing as well? So kind of a big question to end on, but if anyone has thoughts on that sort of, accountability, reform, and state Supreme Courts as an alternative, final thoughts from anyone?
I will jump in with a few thoughts. So that is a big question, and it's a question on which I think there is a range of honorable views, including within the pro-democracy movement that I am a part of. It's a challenging question. I guess I would say a couple of things. One is on the issue of generally what is called sometimes Supreme Court reform. I think the answer very much depends on what you mean by reform. And there are some reforms that would probably be unobjectionable, reforms, for example, that have to do with avoiding even the appearance of impropriety with respect to ethical issues that confront justices. That would be something I would be open to. I think when it gets problematic for me is when you start talking about things that resemble court packing, that either are court packing or that resemble court packing, and that threaten to interfere with what I have always thought of as one of the crown jewels of American democracy, and that is our independent judiciary. And with respect to those proposals, I guess what I would say is a couple of things. One is I think we should give very careful thought to whether you would support that proposal if it were enacted right now. And if the answer is no, because the people who would be packing the court today are people that you don't want packing the court, that is, I think, a big red flag that we're not talking about long-term institutional reform. We're talking about use of political power as a way of bending the court to a certain set of views and wanting to change the rulings of the court by subordinating it to kind of political pressures. And that I think is just a dangerous road to go down, and one that we should think about very carefully, because it's not clear to me where that road ends. The other thing, sort of on a related note, is this: even to get any kind of sort of reforms like that enacted or instituted, you would have to have legislation. And the legislation that we're talking about, presumably is legislation that would not be enacted prior to January 2029. My sense of it is that we have really, really big problems, and that we can't afford to wait that long, and that we should be looking right now as a society at tools that we have at our disposal for protecting vital democratic institutions. And so I'll just give you an example that refers back to the cases that I talked about, the independent agency cases. You might not have, maybe we have a court ruling that I strongly, for one, disagree with, that says that the president can now fire the heads of what used to be traditional independent agencies. And maybe that court ruling will not be reversed for the foreseeable future. But the Congress of the United States has all kinds of tools at its disposal for protecting the independence of independent agencies, and for making sure that agencies don't abuse their power in ways that hurt the American people. They can do that with the power of the purse. They can use it with the confirmation power. They can use it with the power of investigations. And so, just for example, this is not a hypothetical thing. It happened recently with respect to the Federal Reserve, when Senator Tillis said that I am not going to confirm the successor to Jerome Powell unless this trumped-up investigation is dropped. And guess what? It was dropped. So that is just one manifestation of the extraordinary power that a pro-democracy Congress would have if it's willing to use the tools at its disposal. And I guess for me, I think I know there are a lot of people who feel sort of despondent about the trajectory of affairs. I really do feel that we have at our disposal today all the power that we need to avoid a lot of the big problems that are on the horizon. What we need is the political will to stand up to abuses of power. And for me, I think that should be the focus, is electing a pro-democracy Congress and making sure that Congress uses the authority, and state legislatures for that matter, and uses the authorities that are at their disposal to prevent abuses of power, including some of those that we've talked about.
I guess and some of this comes as a reflection as someone who was an abortion rights litigator. I do think that there is perhaps opportunity in a moment when you feel like things are falling apart, that you're moved not to sort of fight over the scraps that are left, but create and put out there a different vision for what you're fighting for. And in the democratic context, I think, not just state courts, but state legislatures, local communities can play a really big role in helping to define that vision, and doing so in a way that maybe we are picking up on ideas that courts today might say, well, there's no basis for that. But in states, under state laws, oftentimes if you don't like the law, you can change it. If you don't like your courts, you can change them. And I think it is not an answer to all that ails us, but it is, for me at least, a bit of hope.
Any other thoughts?
So, yeah, I don't want to keep people much longer, but just sort of one specific, one general. Just picking up on this idea about the states, one of the things that I think has been a complete disaster at the federal level with the Supreme Court is the Rucho decision that's been identified earlier, saying that there's nothing federal courts can do under the Constitution about partisan gerrymandering. States have responded. Some have responded. And the Supreme Court did, in the Moore v. Harper case, at least create some space for state courts as well as state legislatures to say, no, at the state level, we are going to restrict partisan gerrymandering. And so I do think that your suggestion about focusing on, reimagining the way the world could be and trying to have something, do something about it at the state level is a really good one. Then more generally, going back to sort of where I ended my discussion about the Calais case, Section 5 of the 14th Amendment and Section 2 of the 15th Amendment say Congress shall have the power to enforce these protections through appropriate legislation. Congress could, be really assertive and say, fine, this is what you said. We don't agree with you. We're going to reenact very robust voting rights protective legislation. And that by definition under our system would represent the will of the people if Congress were to reenact it, and reenact it, and then say to the Supreme Court, you've had your say, we've had our say. Now, let's see what happens. So I think a Congress that is more robust in the ways Amit described, but also in those kinds of ways, might help, and it might be a step that could precede the kind of ultimate clash over such things as expanding the size of the court, which, I think they're going to, whatever one thinks, whether one agrees with Amit's view or agrees with the views of others who think that it's a step that needs to be taken, that it's going to be discussed in a serious way, I think, more than at any time since the 1930s. I just think that's coming. And so if there are things that could be done before reaching that kind of sort of cataclysmic fight in which Congress reasserts itself, in which states assert themselves in important ways, that might help change the overall trajectory away from where we're headed now.
I'll add one thing very quickly, and that is that if we see our elections as foundational to our democracy and we're looking for the impact of states, then I think the fact that the states are responsible for administering elections is a powerful thing. And I think that the secretaries of state and election officials in the state are understand the consequences of their work and take that job seriously. And I think it would be hard to. I think that's an important line to draw in terms of what one bulwark, if you will, against the erosion of our republic.
Right. Well, thank you once again to the panelists for great discussion. If you're here with us in person, stick around for some snacks. Maybe you'll have a chance to chat with the panelists. If you're online, grab yourself a cookie. You've earned it. And we hope to see you back for a future event.